So, good day again. This is Dr. Meyer and his estate planning prescriptions, and today I'd like to continue our discussion with regard to powers of attorney. If you remember last month, I discussed the general issues and types of powers of attorney that can be used in an estate plan. So now I would like to get a little more specific about each of the individual powers of attorney. The first one I would like to call your power of attorney for personal legal affairs. So this is more or less a general type of power of attorney over any of your legal decisions, such as contracts and so forth. Next month, we'll discuss the healthcare powers of attorney. Now, in California and in many other states, a power of attorney is only given after a person has a chance to review what powers they are actually giving the individual they want to represent them. Oftentimes, the individual who is designated is called your attorney in fact. Now, this doesn't mean that they're attorneys. It just means that they are serving that function for you in a particular regard, particular powers that you have given them. Now, before executing a power of attorney for personal legal affairs, in California, you must read, before you sign it, a number of statutory warnings as to what you are giving up. Because many times in the past, people would say they're less than scrupulous. You know, a grandson might go to his grandmother and say, "Granny, you know, I can pick up your groceries at Safeway and I can pick up your cleaning. You just need to sign these documents." Granny signs the documents, and within a month, she's in the street. So, you know, in order to avoid that kind of problem, a person will read and sign off on the statutory warnings. And this is what they look like. And if you are signing a power of attorney, you can see there are 2 pages here. And they're in bold print, so that if your eyesight isn't very good, you can still read them, okay? Make sure that if you're executing this kind of attorney power in California, that you read the statutory warnings and sign off on them. I've seen some powers of attorney that actually were not signed off on with regard to the statutory warnings, so that's a violation. Okay, now with regard to the power of attorney for personal legal affairs, you want to make sure that there are certain powers that are given under under your power of attorney document. Some of the most significant, and this is a very important one. Are you going to give your power of attorney the ability to amend or revoke a revocable trust? Now, most people, in most trusts, it specifically states in the trust whether someone using a power of attorney can revoke or amend your trust. Most of the time, you do not give that power to someone holding a power of attorney for you. However, under certain circumstances, particularly if one of the individuals may be suffering from dementia, beginning stages, may have a disease that may be terminal, you may want to give your power of attorney the ability to revoke or amend a trust for them. So it depends on the circumstances. Also, you want to make sure that your power of attorney can interact with your trustee. Your trustee is the one that controls all the property in a trust. So your power of attorney for personal legal affairs cannot control trust property. They have to interact with your trustee. So make sure that they are compatible with regard to that. Make sure that your power of attorney allows your agent or your attorney, in fact, to represent you with a business, to operate a business you might own. Make sure that it gives them the power to sign contracts for you. Also, it does or should give them the power to designate beneficiaries of things like policies, life insurance, and retirement plans if you didn't do it and it should have been done. And make sure that they give the ability of the power of attorney to sue in your name if you're unable to do so. So again, durable power of attorney, which means it survives incapacity. Durable powers of attorney, extremely important documents. Don't take them lightly, and make sure that you know what's in them and what their limitations and benefits are. Okay, again, Meyer, Traditions Law.